Indian regulatory chapter 1 Indian regulatory framework learning outcomes. After study this chapter, you will be able to understand meaning of law, law and its sources, types of laws in the Indian legal system, enforcement of law, introduction of major regulatory bodies such as the Ministry of Finance, MCA, Ministry of Corporate Affairs, SEBI, RBI, IBBI, and Ministry of Law and Justice. Chapter Overview. Indian Regulatory Framework. What is law? Sources of law. Process of making a law. Types of law. Types of law. Criminal law, civil law, common law, principles of natural justice. Enforcement of law. Enforcement of law. Major regulatory bodies. Ministry of Finance, MCA, SEBI, RBI, IBBI, Ministry of Law and Justice. Structure of Indian judicial system. Structure of Indian judicial system. What is law? Law is a set of obligations and duties imposed by the government for securing welfare and providing justice to society. India's legal framework reflects the social, political, economic, and cultural aspects of our vast and diversified country. Sources of law. The main sources of law in India are the Constitution, the statutes, statutes, statutes or laws made by Parliament and state assemblies, President or the judicial decisions of various courts, and in some cases established customs and usages. You must be aware that India is a parliamentary democracy. We have a we have a constitution which is the basis and source for all laws. We elect our representatives to the parliament as well as to the legislative assemblies of various states. These representatives of the people make laws in parliament or in their state assemblies as in the case may be. So, parliament is the ultimate law-making body. The laws passed by Parliament may apply throughout all or a portion of India, whereas the laws passed by state legislatures apply only within the borders of the states concerned. The Government of India Act 1935, passed by the Parliament of the United Kingdom, is the precursor for the Constitution of India. It defined the characteristics of government from unitary to federal. Powers were distributed between central and state to avoid any disputes. In 1937, federal court was established and had the jurisdiction of appellate, original and advisory. The powers of appellate jurisdiction extended to civil and criminal cases, whereas the advisory jurisdiction was extended with the powers to federal court to advise Governor General in matters of public opinion. The of Federal Court operated for 12 years and had roughly 151 cases. The Federal Court was supplanted by India's current apex court, the Supreme Court of India. The Constitution of India 1950 is the foremost law that laws with the framework within which our democratic system works, and our laws are made for the people, by the people. The Constitution also provides for and protects certain fundamental rights of citizens. It also lays down fundamental duties as well as the powers and duties of governments, both central and state. The laws in India. The law the laws in India are interconnected with each other, forming a hybrid legal system. The people, the people who vote, the Constitution divi- decided to divide the law-making power between the central government and the various state governments. So, so the Indian Constitution has three lists with central list, state list, and joint list. Concurrent list. Depending on the list in which its figures, a matter would become to become the subject for central law or a state law. For example, income tax is a central subject, so throughout India we have only one law for income tax, which is im- implemented by the central government through 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 the Ministry of Finance. We also have matters for which both central as well as state governments can pass laws. Levy of stamp duty is such an example. Both central government and state government have laws governing levy of stamp. Both both central government and state government have laws governing levy of stamp duty. The process of making law. When a law is proposed in Parliament, it is called a bill. After discussion and debate, the law is passed in Lok Sabha. Thereafter, it has to be passed in Rajya Sabha. It then has to obtain the assent of the President of India. Finally, the law will be notified by the government in the publication called the Official Gazette of India. The law will become applicable from the date mentioned in the notification has the effective date Once it is notified and effective, it is called un it is called an act of parliament. Types of laws in the Indian legal system. The laws in the Indian legal system could be broadly classified as follows. Types of laws: criminal law, civil law, common law, principles of natural justice. Criminal law. Criminal law is concerned with the laws pertaining to violations of the rule of law or public wrongs and same punishment of same. Criminal law is criminal law is governed under the Indian Penal Code 1860 and the Code of Criminal Procedure 1973. The Indian Penal Code 1860 defines the crime, its nature and public punishment, whereas the Criminal Procedure 1951 whereas the Criminal Procedure Code 1973 defines defines executive procedure for executive procedure for executing the punishments of the crimes. Murder, rape, theft, fraud, cheating, and assault are some examples of criminal offences under the law. Civil law: matters of disputes between individuals or organizations are dealt with under civil law. Civil courts enforce the violation of certain rights and obligations through the institution of a civil suit. Civil law civil law primarily focuses on dispute resolution rather than punishment. The act of process and the administration of civil law are governed by the Code of Civil Procedure 1908. Civil law can be further classified into law of contract, family law, property law, and law of tort. Some examples of civil offences are breach of contract, non-delivery of goods, non-payment of dues to lender or seller, defamation, breach of contract, and disputes between landlord and tenant. Common law: a judicial precedent or a case law is common law. A judgment delivered by the Supreme Court will be binding upon the courts within the territory of India under Article 141 of the Indian Constitution. The doctrine of stare decisis, the principle supporting common law. It is a Latin it is a Latin phrase that means to stand by that which is decided. The doctrine of stare decisis reinforces the obligation of courts to follow the same principle or judgment established by previous decision while ruling a case where the facts are similar or one all four legs with the other division. Principles of natural justice. Natural justice, often known as just natural, deals with certain fundamental principles of justice going beyond written law. Nemo judex in causa sua, ode alteram partem, and reasoned decision are the rules of natural justice. A judgment can override or alter a common law, but it cannot override or change the statute. statute. Enforcing the law. After a law is passed in Parliament, it has to be enforced. Somebody should monitor whether the law is binding followed. It is the job of the executive, depending on whether a law is a central law or state law. The central or state government will be the enforcing authority. For this purpose, for this purpose, government for this purpose, government functions are distributed to various ministries. Some of the popular ministries are the Ministry of Finance, the Ministry of Corporate Affairs, the Ministry of Home Affairs, the Ministry of Law and Justice, and so on. These ministries are headed headed by a minister and run by officers of the Indian administrative and other services. The Government of India exercises its executive authority through a number of government ministries or departments of state. A ministry is composed of employed officials known as civil servants and is politically accountable through uh, through through a minister through a minister. Most major ministries are headed by a cabinet minister who sits in the Union Council of Ministers and 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 is typically supported by a team of junior ministers called the Ministers of State. For example, the Income Tax Act is implemented and enforced by the Ministry of Finance through the Central Board of Direct Taxes coming under the Department of Revenue and its administrated by the officers of the Indian Revenue Service. We will see some of the major ministries and the laws which are enforced by them. Ministry of Finance. The Ministry of Finance, Vitt Mantralaya, is a ministry within the Government of India concerned with the economy of India, serving as the service as the Treasury of India. In particular, it concerns itself with taxation, financial legislation, financial institutions, capital markets, central and state finances, and the union budget, etc. and the union budget. As a chartered accountant, many of your day-to-day work life will be impacted by this ministry and its proclamations. These ministry, these ministry is so important that many ministers have preferred to hold the portfolio of finance minister also. One of the important functions of the finance ministry is the presentation of union budget. These annual events is eagerly eagerly avoided by professionals and the common man has it provides for and the common man has it provides for the rates of taxes and budget allocations for the ensuing year. Who presented the maximum number of union budget as finance minister? Sri Morarji Desai during his stint as finance minister between 1962 and 1969 has presented 10 union budgets, making it the highest. The next on the next the next on the next on the list is Sri P. Chidambaram at 9, followed by Sri Pranab Mukherjee at 8, Sri Yashwant Sinha and Dr. Manmohan Doc- Dr. Manmohan Singh have presented 8 and 6 budgets 8 and 6 budgets respectively. Constitution of the Ministry of Finance. Constitution of the Ministry of Finance. Ministry of Finance. Ministry of Finance is the apex controlling authority of four central services, namely Indian Revenue Service, Indian Audit and Accounts Service, Indian Economic Service, and Indian Civil Accounts Service. Also the apex also the apex controlling authority of one of the central central commerce services, namely Indian Cost and Management Account Service. Departments under the Ministry of Finance. departments departments of Ministry of Finance, departments of Economic Affairs, departments of Expenditure, departments of Revenue, department of Financial Services, department of Investment and Public Asset Management, department of Public Enterprises, Ministry of Corporate Affairs (MCA). Ministry of Corporate Affairs is an Indian government ministry primarily concerned with administration of the Companies Act 2013, the Companies Act 1956, the Limited Liability Partnership Act 2008, and the Insolvency Bankruptcy Code 2016. Responsible mainly for the regulation of Indian enterprises in the industrial and services sector. The ministry is mostly run by civil servants of the ICLS cadre. These these officers these officers are elected through the civil services examination conducted by Union Public Service Commission. The hi- the highest the highest post the highest post Director General the highest post Director General of Corporate Affairs DGCOA is fixed at apex scale of ICLS civil service servants. Ministry of Home Affairs Gृह मंत्रालय is a ministry of the Government of India. It has an Interior Ministry of India. It is mainly responsible for the maintenance of internal security and domestic domestic policy. The Home Ministry is the Home Ministry is headed by Union Minister of Home Affairs. The Home Ministry is headed by Union Minister of Home Affairs. Departments of Ministry of Home Affairs: Department of Border Management, Department of Internal Security, Department of Jammu, Kashmir and Ladakh Affairs, De- Department of Home, Department of Official Language, Department of States, Department of Official Language, Central Translation Bureau, Central Hindi Training Institute, Directorate of Consensus Operations, Ministry of Law and Justice. Ministry of Law and Justice in the Government of India is a cabinet ministry. Deals with the management of legal affairs through the legislative department deals with the legislative activities through the Department of Legal Affairs deals with the administration of justice in India through TRF, the Department of Justice. The Department of Legal Affairs is concerned with advising the various ministries of the central government, while the Legislative Department is concerned with the Department of Legal Affairs is concerned with advising the various ministries of the central government, while the Legislative Department is concerned with drafting of principal legislation for the central government. Departments of Ministries: Ministry of Law and Justice, Department of Legal Affairs, Legislative Department, Department of Justice, Department of Legal Affairs, Legislative Department, Department of Justice. The Security and Exchange Board of India (SEBI), the Securities and Exchange Board of India (SEBI), it is the regulatory body for securities and commodity market in India, under the ownership of Ministry of Finance within the Government of India. It was established on 12 April 1988 as an executive body and was given statutory powers on 30 January 1992, तरफ the SEBI Act 1992. Reserve Bank of India (RBI), Reserve Bank of India is India's central bank and regulatory body responsible for regulations of the Indian banking system. It is under the ownership of Finance. It is under the ownership of Ministry of Finance, Government of India. It is responsible for the control, issue and maintaining supply of the Indian rupee. It also manages the country's main payment system and works to promote its economic development. भारतीय रिजर्व बैंक नोट मुद्रण is a specialized division of RBI, which its prints and mints Indian currency notes (INR), Indian currency notes in two of its currency printing presses located in Nasik and Devas. RBI established the National Payments Corporation of India as one of its specialized division to regulate the payment and settlement systems in India. Deposit, insurance and credit guarantee corporation was established by RBI as one of its specialized division for the purpose of providing insurance of deposits and guaranteeing of credit faculties to all Indian banks. Insolvency, bankruptcy Board of India (IBBI), Insolvency, bankruptcy Board of India (IBBI). It is the regulator for overseeing insolvency proceedings and entities like insolvency professional agencies, insolvency professionals, and information utilities in India. It was it was established on 1st October 2016 and given statutory powers through the Insolvency and Bankruptcy Code, which was passed by Lok Sabha on 5th May 2016. It it covers it covers individuals, companies, limited liabilities, partnerships, and partnership firms. The new code the new code will speed up the the resolution process for stressed assets in the country. It attempts to simplify the process of insolvency bankruptcy proceedings. It handles it handles the cases using two tribunals like National Company Law tribunals and Debt Recovery Debt Recovery Tribunal. Structure of the Indian judicial system: when there is a dispute between citizens or between citizens and government, these disputes are resolved by the judiciary. The functions of judiciary system of India are regulation of the interpretation of the acts and codes, dispute resolution, promotion of fairness among the citizens of the land. In the hierarchy of courts, the Supreme Court is at the top, followed by the High Courts and District Courts. Decisions of a High Court are binding in the respective state but are only pursues, persuasive in other states. Decisions of Supreme Court are binding on all high courts under Article 141 of the Indian Constitution. In fact, a Supreme Court decision decision is the final word on the matter. Supreme Court: the Supreme Court is the apex body of judiciary. It was established on 26 January 1950. The Chief Justice of India is the highest authority appointed under Article 126. The principal bench of The Supreme Court consists of 7 members, including the Chief Justice of India. Presently, the number has increased to 34, including the Chief Justice of India, due to the rise in the number of cases and workload. An individual can seek relief in the Supreme Court by filing by filing a writ petition under Article 32 of Indian Constitution. High Court. The highest court of appeal in each state and union territory is the High Court. Article 214 of the Indian Constitution states that there must be a High Court in each state. The High Court has appellate, original jurisdiction and supervisory jurisdiction. However, Article 227 of the Indian Constitution limits and a High Court's supervisory power. In India, there are 25 High Courts, one for each state and union territory, and one for each state and union territory. Six states share six six states share a single high court. A an individual can seek remedies against violation of fundamental rights in High Court by filing a writ under Article 226, which is the oldest High Court in India. The oldest High Court in court in the country is the Calcutta High Court, established on 2nd July 1962. District Court. Below the High Courts are the District Courts. The Courts of District Judge deals with civil law matters, that is, contractual disputes and claims for damages, etc. The Courts of Sessions deals with criminal matters. Under pecuniary jurisdiction, a civil judge can try suits valuing not more than rupees 2 crore. Jurisdiction means jurisdictions. Under pecuniary jurisdiction, a civil judge can try suits valuing not more than rupees 2 crore. Jurisdiction means jurisdiction means the power to control. Jurisdiction means the power to control. Courts get territorial jurisdiction based on the areas covered by them. Cases are decided based on the local limits within which the parties re, reside, or the property under dis or which the parties reside, or the property under dispute is situated. situated. Metropolitan courts. Metropolitan courts are established in Metropolitan courts are established in metropolitan cities. In constitution with the High Court where the population is 10 lakh or more. Chief 10 lakh or more. Chief Metropolitan Magistrate has powers as Chief Judicial Magistrate and uh, and Metropolitan Magistrate has the court of a magistrate of the first class.